Well, it's definitely a good day to be inside watching a webinar.
Absolutely.
Well, the weather here
We're,
is pretty bad.
we're not missing anything.
No. Welcome to all of you. We'll go ahead and get started. My name is Karen Cage. I'm the CEO here at RailComp. And I'd like to introduce to you the others that will be joining us today. We have Michael Young. Michael is with the Lapeer and Upper Thumb Association of Realtors. He is on their board of directors, and he is also the president of RailComp's Board of Governors. We have Fran Green, who has been with RailComp since she was about 2, and she was actually with RailComp 1. Yes, there was a RailComp 1. So she brings a lot of history and a lot of knowledge, and she'll be joining us today. And also we have Brian O'Keefe, and I'd like to tell you a little bit about Brian. Brian is a founding partner of Lippitt O'Keefe, PLLC, a Birmingham, Michigan-based law firm. He supervises the firm's transactional real estate business and personal planning departments. Brian has been serving Southeastern Michigan businesses, entrepreneurs, and their families for almost 40 years. Brian is also outside general counsel to RailComp 2, the largest real estate multiple listing service in the state of Michigan. Over the course of his career, Brian has been legal counsel in transactions with a cumulative value in excess of $1 billion. He received his Bachelor of Arts degree from Michigan State University and received his Juris Doctor degree from the Catholic University of America. Brian's professional memberships include the State Bar of Michigan, the Oakland County Bar Association, and the American Bar Association. Brian is a longtime philanthropist and has served on numerous community and company boards and committees, including the Manresa Retreat House and the Young Entrepreneurs Organization. Brian currently lives in Birmingham with his wife, Robin, and their 4 kids. So before we get started, let's just do a little bit of housekeeping. The button at the bottom where you see the Q&A, that's where we would like for you to enter your questions, and we will answer those questions at the end of the presentation. The presentation will take about an hour, and that will leave us an hour to go through all of the questions, hopefully all of the questions. If there are some that we don't get to, we will follow up in writing. But we're hoping that we'll be able to get to just about all of them. So if you could put your questions down there, that would be helpful, and then we'll go through them at the end. Also, this will be recorded, so you'll be able to access it through RailComp's YouTube channel. So we're going to go ahead and get started. Brian, you would like to kick it off?
Thank you for the nice introduction, Karen. Good afternoon, everyone. Thanks for having me. It's a pleasure to speak with you all today and hopefully enlighten you on the current state of affairs with regard to the real estate industry, the residential real estate industry here in the state of Michigan, and the NAR settlement that has precipitated a number of changes that you're all in the middle of experiencing and are going to be experiencing in the weeks and months to come. Before we get started, I'd like to read to you a disclaimer. I'm going to read it in full so that we're all on the same page here. Due to the nature of this town hall, please be advised of the following. The information disseminated during this town hall may not be exhaustive of the subjects covered during this town hall or of all of the subjects which may impact the business of the participants of this town hall. By disseminating information during this town hall, Lippitt O'Keefe and its agents are not inviting or establishing or intending to invite or establish any attorney-client relationship, principal-agent relationship, or any other legal or business relationship. The attorneys at Lippitt O'Keefe are licensed to practice law only in the state of Michigan, and nothing during this town hall shall be construed to constitute legal advice under the laws of any other jurisdiction. The attorneys at Lippitt O'Keefe are not accountants nor tax advisors, and nothing during this town hall shall constitute or be construed to constitute tax advice or a tax opinion. Finally, by participating in this town hall, Lippitt O'Keefe and the participants of this town hall are not intending to coordinate the actions of competitors in violation of state or federal law, but rather we are sharing information in an attempt to comply with applicable state and federal law. This is a little outline of what we're going to be discussing today. We're going to talk about the genesis of the Morrill and Sitzer cases. We'll talk about the nationwide settlement. We'll go through some of the practice changes that are required. We'll provide further detail on the implementation and timing of those changes. We'll discuss in some detail the changes to the MLS system and forms. And then, as Karen mentioned, we'll open up the floor to questions. Hopefully you'll all have some good questions for us, and we'll be happy to go through those and get to as many of them as possible. We're planning on about an hour for question and answers. So the Sitzer and Morrill case. The real estate industry has been under scrutiny since almost the beginning of time. Since the 1950s, the Department of Justice, the Federal Trade Commission have been looking at the real estate industry. And you might ask yourselves, why us? Well, anytime that there is a perception that competitors are coordinating activities, those industries come under scrutiny. All of you out there are, although you're colleagues and you cooperate with one another, you're also competitors. And some of the actions that NAR has been taking since the very early days have led the Department of Justice to scrutinize the real estate industry. What transpired over all those years came to a head in 2017 when the Sitzer lawsuit was filed in federal court in the state of Missouri. This case was brought by a group of plaintiffs' lawyers representing sellers of homes in the state of Missouri. And the plaintiffs claimed that real estate commissions were too high and that the cooperative compensation rules that were promulgated by NAR were resulting in those in that outcome. That case was followed in 2019 by the Morrill lawsuit. You've probably heard these names before, Sitzer and Morrill. The Morrill lawsuit was brought in the Northern District of Illinois against NAR, and it added defendants, and it greatly expanded the list of defendants that were being pursued over these cooperative compensation rules. And the Morrill suit pretty much brought the lawsuit to a national level. Real Comp was named in that suit, but was not named as a defendant. We were named as a possible conspirator, and we had to produce documents by way of subpoena, but we were not named in the lawsuit. A number of other MLSs were named, but Real Comp was not. Along around the same time, the Department of Justice and the Federal Trade Commission began looking at NAR and other aspects of NAR's rules and regulations. And to this day, that scrutiny is ongoing. There was a tentative settlement that took place in 2000. NAR thought that they had settled the case with the DOJ. The DOJ thought that they did not quite get to settlement. And since that time, there's been a lot of procedural action in the United States Court of Appeal for the District of Columbia. But presently, that lawsuit has not been, that investigation and suit has not been settled. And there's an ongoing Department of Justice action pending against NAR on, among other things, some of the rules relating to the matters that we're going to be speaking about. The Sitzer case, in fact, in October of 2023, went to trial. Not often that these kinds of cases go to trial, but this case did go to trial. And the jury awarded the plaintiffs in that case $5.36 billion in damages. Now, mind you, that was only for the sellers of real estate in the state of Missouri, $5.36 billion. So you can imagine the size of the damages that that NAR and other defendants were facing in the Morrill case, because the Morrill case was much larger, was almost a national level case. And so the damages, the potential damages in that case were astronomical. After the jury awarded these damages, dozens of copycat cases were filed around the country. And because of the size of the judgment, because of the filing of these copycat cases, and because the Morrill case was being lined up to go to trial sometime in 2024, NAR decided that they had to settle these cases. And that's that is what has led to the current settlement. To reduce liability, to keep NAR and some of the larger brokers in business, everyone thought that it was prudent to settle the cases. So there was finally agreed upon a national settlement. The settlement is nationwide. However, I want to point out that it only settles cases against with the sellers of real estate. It does not settle cases that are pending with plaintiffs that are buyers of real estate. And these plaintiffs in these buyer cases also claim that they paid outsized commissions and or too much for homes as a result of NAR's clear cooperation and compensation policy. Now, interestingly, just this morning in the trade papers, there has been some discussion about there being a sort of a tentative high level talk of settling the buyer cases. So it'll be very interesting over the coming weeks and months to follow that development. But there is now some talk that these buyer lawsuits are going to be settled as well, which would be a good outcome for all of us in the industry. The settlement agreement resolves claims against NAR. It resolves claims against all local realtor associations. It resolves claims against all association-owned multiple listing services, which includes RealComp. And it resolves claims against brokerage firms with a principal who is a realtor and whose 2022 volume was $2 billion or below. I've been asked this question before. If you're a broker with a volume of below $2 billion in 2022, then you need not do anything else. The settlement covers you. There's nothing to opt in over or to do anything over. You will be covered if the settlement is finally approved by the court. We're in a period of time where, all class actions act this way. We're in a period of time where the plaintiffs are still sending out notices and making sure that people opt into the class. So this case will not be settled finally until the end of the year, but we're in this period of time where everybody is trying to effectuate the settlement. Besides all of the parties that were covered by way of the settlement, NAR was able to reduce the settlement amount to $418 million from the $5.6 billion that they were facing by way of the Sitzer judgment. And of course, it also does away with all of those copycat cases and the moral case. So the settlement amount was greatly reduced over the judgment amounts, and was one of the impetuses behind settling the case. As I said, the settlement covers all persons who sold a home listed on an MLS anywhere in the United States where a commission was paid to any brokerage in connection with the sale of the home. In Michigan, the home sales that are covered are from October 31, 2017 onward. The sale of the homes before that period of time are not likely to be brought in by way of a lawsuit because of the statute of limitations that would bar claims before that period. There are two types of entities that are not automatically covered by this settlement. Those are brokers with a residential transaction volume over $2 billion in 2022. If any of you out there fall into that category, then you have to opt into the settlement. There was a methodology for doing that. There was an exhibit to the settlement agreement that provided for an opt-in option for brokerages of that size. Many brokers around the country that are that size have opted into the settlement. There are, however, a few brokerages that have decided to fight with the plaintiffs over the issues, and some of those fights are ongoing. Primarily, the brokerages that were in that category that are fighting over the amount of settlement dollars that they have to pay, because in some scenarios, those amounts are very, very high. Non-realtor MLSs were also not covered by the settlement. There was an opportunity and an option for non-realtor MLSs to opt into the settlement. Again, a number of those MLSs have done so, but there are also some non-realtor MLSs who have chosen not to opt in and are negotiating with the plaintiffs. Again, it is primarily over dollar amounts that would need to be paid in order to opt in. Okay. To summarize, RealComp is a released party under the agreement and does not have a monetary obligation to pay a settlement fee. RealComp has executed Exhibit B, which was the means by which to opt into the settlement. And we have to implement practice changes, which we are in the process of doing. That's what brings us to this town hall today. I think I've covered the other points, so we can go on, Fran. So what are the NAR settlement required practice changes, and how are we going to implement those? The settlement deadline is August 17 of 2024, but as most of you know, we have already begun implementing the changes. The primary changes are as follows. Offers of compensation are now prohibited from the MLS. As such, all compensation-related fields were removed from RealComp during the week of July 15th, 2024. Brokers and agents must now communicate offers of compensation via phone, email, in person, their own websites, etc., but not through the MLS. So just to be clear, everyone, you can still do business as usual by way of offers of compensation to one another. You just cannot do it through the MLS. The MLS, RealComp, among all of the other MLSs, was ruled to be a coordinator of activity, which again runs afoul of the antitrust rules. So as a coordinator, they no longer want the MLSs to be used to address offers of compensation. To address these issues, agents posting offers of compensation in remarks will be prohibited from doing so as we go forward, and up to as of August 14th, 2024, that we will no longer be able to do any kind of offer of compensation anywhere on the MLS. And in addition, there will be some words that we're going to limit you from using in the MLS fields. Karen will get into more detail on that later. Also, certain disclosures must be made to sellers, prospective sellers, and buyers. The primary disclosure that needs to be made is that broker compensation is not set by law and is fully negotiable. You will see in the RealComp forms that are on the MLS, we have made this clear in all of the forms, and we have in boldface and larger type that broker compensation is not set by law and is fully negotiable. If you want any additional details on any of these settlement issues, you can go to facts.realtor. It's a site that's been set up by NAR. It's kept up to date. Things are changing regularly. Things are changing by the day, as I mentioned. Even this morning, as I said, there's talk of the buyer lawsuits being settled. So we're all learning as we go. NAR and its advisors are learning as they go. And so for up-to-date information, you go to facts.realtor. Some of the other practice changes that are required: MLS participants and subscribers must not represent that their brokerage services are free or available at no cost to clients. One of the proofs that came in the Sitzer case was that buyer agents often say, well, my services are free to you, Mr. and Mrs. Buyer. I will be paid by the seller and the seller's broker. Well, that's not entirely true, and it wasn't true in many circumstances, and it varied among transactions. So that was deemed to be sort of an abusive practice, and there has to now be a disclosure that you cannot represent that your brokerage services are free or available at no cost, unless that is in fact the case, and you are receiving absolutely no compensation in any way, shape, or form from the transaction. Also, a written agreement is now required for MLS participants acting for buyers. Of course, in history, many times buyers did sign and were signing written agreements, but now it is mandated. You must have a written agreement with your buyer before you show that buyer the very first home. So you have to sit down with your buyer client prior to viewing homes and come to a written agreement on how you'll be compensated. Again, RealComp has provided a buyer agency agreement, designated agent, and a purchaser agency agreement traditional that contains the necessary requirements for the written agreement. In the listing agreement between the seller and the seller broker, The language required by the settlement agreement must be conspicuously displayed. And as I said, it has to say brokerage commissions are not set by law and are fully negotiable. We have this language in the exclusive right to sell agreement that we've prepared for Real Comp. We have it in the exclusive agency agreement. We have it in the limited agency agreement. We have it in the other agreements where it needs to be set forth. Finally, and this is very important, MLS participants acting for sellers must conspicuously disclose to the seller and obtain the seller's approval for any payment made to another broker. The disclosure must be in writing, must be made in advance of payment, and must specify the amount of such payment. Accordingly, we've prepared and have provided to Real Comp a co-broker compensation agreement that will set forth what the seller broker is getting, what the buyer broker is getting, how it's to be split, and it requires that the seller initial each page and sign the agreement. That way you will all be in compliance with the settlement agreement. This document can be prepared at the same time, contemporaneous with your listing agreement. So you can have a listing agreement where it says that you will get 5% commission, and then you can talk to the seller about what portion of that commission they would like to share with the buyer broker, if any. The seller can then agree in this co-broker compensation agreement that the buyer broker will get 2% or 2.5% or 1%, whatever the number is. And you can have your seller client sign that document. And then as brokers bring buyers, you will have a document that the buyer broker can execute and agree to receive the 1% commission, the 2% commission, whatever it is. We were asked a lot of questions in preparation for this about, why is the government picking on the real estate industry? It's not necessarily picking on the real estate industry. And one of the examples that I've used previously, if a lawyer is going to be paid by someone other than his or her client, the lawyer must also get a written agreement that makes very clear who is paying the fee and why, and they have to disclose it to their client. So in a divorce situation where a wife may be paying for the husband's lawyer, or in a situation where young homeowners are buying a house and the parents are going to pay the lawyer to prepare the documents, we have to be very clear as to who we are getting paid from, so that our duty of loyalty remains intact and everyone understands the situation. So this is along the lines of that. So breaking down the new requirements. And this is sort of the impetus behind this, the whole change in the industry. The multiple listing service shall not fix, control, recommend, suggest, or maintain commission rates or fees for services to be rendered by participants. Further, the multiple listing service shall not fix, control, recommend, suggest, or maintain the division of commissions or fees between cooperating participants or between participants and non-participants. This is right out of the settlement agreement. This was the main finding of the jury in the Sitzer case, and that's why it is in the settlement agreement so clearly. So what are we going to do? As I talked about, this is the new form that we have in the Real Comp MLS. It's a co-broker cooperation and compensation agreement. It provides clearly, and we believe that it meets with the terms of the settlement agreement, as to what the listing broker is doing, who they're representing, what the cooperating broker is doing, who they're representing, what kind of agreement the cooperating broker has. You'll see that the cooperating broker has to disclose to the selling broker, the listing broker, what kind of agreement they have with their client. And then in this form, on subsequent pages, is a section where you can break down what you're getting as the listing broker and what the buyer broker is getting, and how the fees are going to be paid. And you can see at the top, the property owner has to sign initially each one of these pages and has to sign this. So it meets with this. It meets with the terms of the settlement agreement, which requires that a seller understand. The settlement agreement requires that the seller understand if the listing broker is sharing a fee with the cooperating broker. So the seller has to understand that and be fully advised of that. This form will allow you to do that. So again, MLS participants and subscribers must disclose to prospective sellers and buyers that broker compensation is not set by law and is fully negotiable. This must be included in conspicuous language as part of any listing agreement, buyer written agreement, and in the pre-closing disclosure documents. So to the extent that you're using non-real comp forms, you should be wary and ensure that the forms that you're using, whether you prepare them yourself or whether you use a broker form, a Century 21 or a Real Estate One form, you should be clear. You should be sure that those documents have this language in them. Conspicuously disclose in writing to sellers and obtain the seller's authority for any payments or offers of payment that the listing participant or seller will make to another broker, agent, or other representative acting for buyers. This disclosure must include the amount or rate of any such payment, must be made in writing, and must be made in advance of any payment or agreement to pay. So again, you don't need to necessarily use the document that we've provided, the one that we just went over. But to the extent that you're going to prepare your own document, please be sure that it is presented to the seller ahead of time and that the seller understands exactly what the buyer broker is going to be getting and agrees to it in writing. Again, breaking down the requirements. These are the requirements for the written buyer agreement. The written buyer agreement must have specific and conspicuous disclosure of the amount or rate of compensation the participant will receive, or how this amount will be determined to the extent that the participant will receive compensation from any source. The amount of compensation must be set forth in a manner that is objectively ascertainable and not open-ended. Now, we've been asked a lot of questions about this, and it sounds like legalese, and to some extent it is, but it comes right out of the settlement agreement. So we want to have it in our forms so that the DOJ can see that we're attempting to comply with the settlement agreement. Objectively ascertainable and not open-ended is just what it means. It has to be a number or a percentage. It can't be, I will take whatever the seller broker will pay me, or I will take an amount that I determine at closing, or I will take an amount that you and I agree to at some point in the future. When you get your buyer to sign this buyer agreement, you should have in a document what you will receive. It doesn't mean, we've also been asked this question, it doesn't mean that you can't change this going forward. So if you have an agreement that you'll be paid $5,000 on closing, but you've now spent months and months showing this buyer homes, and the buyer has changed its mind and is looking at larger homes, and you've put in a lot of additional work, you can go back to the buyer and say, you know what, for the reasons X, Y, and Z, I think that 5,000 is no longer a fair amount. Please, let's revise our agreement, and I'll take $10,000 now. So you can amend the agreements. Or if the seller's broker is motivated to pay you a higher an amount because it's a larger home, or it's a home that's having trouble being sold, and the seller broker offers you a higher commission than you may have in your buyer agreement, you can go to the buyer and request that there be a revision to this buyer agreement. As I said, the buyer agreement also needs to have a statement, and you have to be able to say that broker fees are not set by law and are fully negotiable. And finally, you cannot take an amount that is larger than the amount that you agreed to take in your buyer written agreement. As I said, you can amend the buyer written agreement if you're going to take a larger amount, but you must disclose to the buyer in writing and have the buyer sign off on a document if you're going to take a fee that's larger than what you initially agreed to. Our buyer agency agreement designated agency and our purchaser agency agreement traditional both have all of these terms in them and are compliant with the settlement. So what changes are coming to the MLS system and what enhancements are being made? You're going to see that, and we've talked about this a little bit, but you're going to see that in the agreements that we have, this is a sort of a close-up of one of them. It talks about bar commissions are not set by law and are fully negotiable. And you can see at the bottom, it says the parties understand, acknowledge, and agree that the foregoing agreement on compensation is objectively ascertainable and not open-ended. But you can fill in a percentage, a dollar amount, some other amount, or you can describe in the other section how you're going to be paid. So it can be a sliding scale or some kind of variable amount depending on the work that you're doing. But it does have to be objectively ascertainable and not open-ended. We are continuing to monitor the settlement. As I said, it's not the settlement, although many believe that it's fully and finally completed, it's not. There's ongoing things happening all the time with the settlement. It won't be finalized until the end of the year. NAR's making changes in their guidance. We're watching the guidance that NAR is giving, and we're also watching what other large MLSs around the country are doing so that we can be up to the highest level of compliance and give all of you the most vibrant MLS that is possible, yet compliant with the settlement agreement. So the following forms have been updated and are now available in Docs Plus. A co-broker cooperation and compensation agreement, which I spoke about. The limited service listing contract. The exclusive right to sell or lease contract. A purchaser agency agreement designated agency. A purchaser agency agreement traditional. MLS entry only contract. There will be an exclusive agency agreement added. There will be other agreements added. There'll be purchase agreements added. Those are all coming and will be available to you. So, as I said, we're continuing to monitor things. In the last few weeks, we've learned that some MLSs, including the California MLS, which is the largest in the country, have reconsidered their decision to add pre-sale concessions to their data entry platforms and systems. California had both a series of forms that they provided early on after the settlement, and also had a pre-sale concessions in their MLS. And immediately, the DOJ and some consumer protection groups came down pretty hard on California, the California MLS, saying that the forms were not compliant with the settlement, were designed to get around certain aspects of the settlement. There's been talk in the industry that people are going to use the pre-sale concession fields to sort of get around the prohibition on compensation in the MLS. We're going to use the concession fields as kind of a backhanded way of illustrating what commissions might be offered. So RealComp has taken the approach that we want to be conservative, we want to be compliant, we want to balance that against providing you with the best MLS possible. But based on these developments, the RealComp Board of Governors agreed that RealComp will not be adding pre-sale concession fields as previously communicated due to the potential risk of lawsuits. We want to avoid a lawsuit against RealComp. We want to avoid a lawsuit against our shareholders, and we want to avoid lawsuits against all of you. So with the abundance of caution, we're going to, for the time being, not have pre-sale concession fields in the MLS. This doesn't mean that you can't offer concessions. This doesn't mean that you'll see, Karen's going to get into some of the details in a minute here. It doesn't mean that post-closing, we will allow you to list all the concessions that were made so that people can track what occurred in a transaction, and that the appraisers that are out there will be able to determine what, for appraisal purposes, what the value of the home might be. But we are going to leave out pre-sale concession fields for the time being. Karen, you want to take over?
Sure. Thanks, Brian. Well, we're going to talk a little bit about some new closing concessions that will be added actually tonight. Those are going into the system tonight. You currently have the ability to add concessions when a property closes. You can say, yes, there were concessions. You can have an amount, give an amount, and you can say what it was for, or just mark that it was for other. And those fields will appear on your listing at the bottom where we show the sold information. But we've expanded that a bit to be able to offer additional information. All of this started through conversations we had with some appraiser subscribers. But as we went through, we found that this is going to be beneficial for all subscribers, not just the appraisers. So you'll see that things are going to move around just a little bit. And this is, again, when you go in and say, I want to mark the property sold. So the first thing it'll tell you is, in this field, you shall not make offers of compensation. You should not disclose compensation, represent your services are free, or make any concession limited to or conditioned on the retention of or payment to another broker or representative. You're going to see that so often, you'll have it memorized, because we don't have a choice. We are obligated to display those disclaimers everywhere you go. So you're going to see that throughout the add edit. You're going to see it on the listings when you print them out. And that is to make sure that we're compliant with the terms of the settlement. So when you mark your property sold, the first question you'll be asked is, are there closing concessions, yes or no? None of these fields are mandatory. All of these fields are optional. So you can say, yes, there were closing concessions, and you can say, were there concessions for closing costs? And you can put an amount in there. Were there concessions for property improvement costs, such as a new roof or a driveway? And you can put an amount in there. All of these will be dollar amounts. Were there concessions for financing costs? Again, you'll put your dollar amount in there if that was the case. And were there any concessions for professional fees other than broker commissions? And this is really talking about maybe lawyers or some other professional services that were necessary to assist in getting the property closed. And then there is the kind of catch-all for concessions for other costs, again, other than broker commissions. If you fill any or all of those in, where it says total closing concession amount, the system will total that for you. If you choose not to break it out and just put something in the total, you can do that too. So you can put a total in without explaining what they're all for, but we really would like for you to fill those fields out and show the breakdown if you can, but you don't have to. You're not required to. And again, all of these fields are optional. None of these are mandatory. And then lastly is the closing concessions comments. Let's talk a little bit about that. This is a 300-character text field, and it allows you to explain the concessions that the seller provided. But there will be some restrictions on what information you can put in this field, in this text field. For example, there'll be some restricted words such as you can't say compensation, you can't say commission, you can't say percent of close price. All of those things that would do with the compensation to a buyer agent, bonus, dual, variable. If you enter that information, you will not be allowed to go further to save the change. It won't let you go any further. So it'll alert you and say, you need to make some changes here. Right now, some of those would be a warning, but there'll also be some that will stop you from saving the listing. And that little red box will come up next to this field, and it will explain to you why you can't move forward. We've tried to make this as, I won't use the word easy, but we've tried to explain it very well as we go to make sure that it is easier for you to fill in this information, because we understand what a big change this is. This is a picture of what the new listing change sheet looks like. If you print out the listing change sheet, you'll see where all those concession fields are. They're the same fields as you saw on the previous screen. This is just the on-paper side. Maybe you want to print it out and have your seller sign it, go through it with them. It'll show you where all those fields are. And again, when you fill in the amounts, you'll need to total that amount. And then you can go online and enter it there, or have maybe your office assistant does that, or your personal assistant does that. Once you fill this out, then you can update the listing online. This is what the listing itself will look like when you pull up the property. At the top is what it looks like, what it used to look like, where it shows you sub-agent compensation, buyer agent compensation. You see that at the very top in that pale yellow. And one of the fields that was included there was referred to as compensation arrangements. That included if there was a bonus offered, or if it was a dual or variable commission, or if there were excluded parties. Let's say your seller said, I've been working with a friend of mine who really wants to buy my house, but I want to list it, but if that friend buys it, then I want them excluded from the agreement. And that would be where you would mark that information. Today, or after today, what you'll see is shown at the bottom. You see the compensation fields have been removed. The compensation arrangements is now referred to as listing exemptions, because the only thing left in that category is if there is a personal exclusion, like I just explained, with your friend that may want to buy the home. At the bottom is where you'll see, and this is more information on the seller concessions. Above, you'll see what you had today. You had, yes, there were concessions, 300,000, or pardon me, that's the sale price. It would show you what those concessions was $5,000. But now you'll have more detailed information, because that's what you filled out on that previous screen that we went through. The closing costs, financing costs, professional fees, all of that will be broken down and shown to you on this particular field on the bottom of the listing. And again, you'll see the disclaimer that talks about what can and can't be shown there. Anywhere on here, I believe we have now links back to those forbidden words. We're trying to link from any field that will stop you from going forward if you have certain words or terms. We have links that will go to the corporate website and show you what those words are. So you'll have a better understanding of why you can't move forward.
So let's just summarize for a minute before we get into the question and answer portion of this. There are really 5 or 6 things that everybody has to keep in mind. And although there is a lot of upset over this settlement, many of the rules are pretty simple and straightforward. The first one is that the MLS can't be used to make offers of compensation. I'm probably older than most of you out there. I've been practicing law since 1986. There was a time before the MLS when business was done now how it's going to be going forward. And it's never good to go backwards, particularly in this time of great information and data. But we can't use the MLS any longer to make offers of compensation. So you're going to have to go back and do business like some of you might have done before there was an MLS around. You'll have to make offers of compensation over the phone, by email to one another, and agree on compensation amongst yourselves outside of the MLS. The second thing is that we have to be sure that we disclose on all of our forms that commissions are fully negotiable and not set by law. The third thing we have to be aware of is that we can't say that we're working for free or that we're not going to be compensated. Even if you're getting compensation from another party, you can't tell your buyer that you're not getting compensated or your services are free. When commissions are agreed upon, they have to be objectively ascertainable and not open-ended. They can't be, I'll take what I can get, or We'll agree on it at closing. You have to have an agreement that's clear, and that's for everybody's protection. It's for your protection, and it's for the protection of the buyers and the sellers. There must be a buyer agreement in place before you show your buyer the first home. That's your obligation as a buyer's agent. You have to have a document, an agreement in place. And it has to have in it the elements of a contract, that what services you're going to be providing, and what you're going to be compensated and how you're going to be compensated for those services. And then last, the seller has to be aware of any commission sharing that might be going on between the seller agent and the buyer agent. The seller has to be aware of it. It has to agree to it in writing, and it has to agree to it before the commission is paid or agreed to be paid. So you're best advised to get a document like the co-broker compensation and cooperation agreement that we prepared. You're best advised to get that in place as you're listing the home. You can get a listing agreement signed, and you can get that agreement understood and signed. And then, as I said, as buyer agents come to you, you can say, hey, I've got an agreement with my seller that I will pay a good buyer agent, X% or Y%, whatever it may be. So those are the main things to take out of all of this. As I said, Real Comp is part of the settlement. Real Comp is going to implement all these changes. We're going to moderate all of the changes with providing all of you the best advice and the most vibrant MLS we can going forward. And we thank you. So before we wrap up, what's going to happen in the future? Hard to predict. As I said, just this morning, there's talk about the buyer lawsuits that, again, could result in billions of dollars of damage, could result in additional practice changes. There's some talk now that those are going to be settled, and we'll see what those settlements bring for us. Nevertheless, the Department of Justice and the Federal Trade Commission will continue to investigate the real estate industry. The real estate industry, as I said, has been under scrutiny for years because there have been attempts in the past to try to coordinate. I would argue very vociferously that that's not the case in this industry, but the Department of Justice clearly believes that it is. So there'll continue to be investigations. I believe that NAR will continue as an organization. NAR provides a lot of good aspects to the industry, but I think they're going to have to reevaluate some of their practices. What's the industry going to look like? Will there be non-realtor participation in MLSs going forward? Will the MLSs continue to merge with one another? There's been some mergers around the country of large MLSs. Those will probably continue. Will there be other structures? Will there be other MLS structures, or will other competitors come into the industry? I think that as the industry continues to move forward, there will be competitive structures that might take place. The real estate industry is a very vibrant industry. It drives a large part of the economy in the United States. So I think that when those things are in place, there's always room for competitors and room for changes. Will the number of licensed professionals change? There's been talk about there being a real that the settlement might impact the number of licensed professionals. It might drive buyer agents out of business. I don't think that will happen. There might be some fallout. People that are doing this part-time or not up to industry standards might drop off, but that should help. That should help with all of you that are practicing as agents full-time, that are very professional in their activity and in the way that they approach their business. And sometimes when some of the weaker agents, in any industry fall off, it helps the remainder survive and excel. So a lot of things will be happening in the future. we will continue to keep you updated through these kinds of town halls and through other education that RealComp provides. And we will work with the associations to make sure that you are all getting the best advice that we can possibly give. With that, I think we're going to open it up to questions and answers.
Yeah, we just have a few. Looks like we just have a few questions, Brian. How do we handle a buyer agreement when we have the seller?
So that's a very good question that came up multiple times and multiple ways in the town hall that we just did. You as the seller agent are not responsible for making sure that the buyer agent has a buyer agreement. You're not responsible for that, nor are you responsible for a buyer who might walk into an open house and you're unsure that whether or not they're represented. I mean, for good business practices, you should ask anyone entering an open house whether they're represented or not, because it might provide you with an opportunity for a dual agency or some other kind of relationship. So it's wise from a business perspective to know who you're showing a home to. And of course, if you're going to reach an agreement with a buyer agent on what you're going to pay that buyer agent from a seller commission that you might be receiving, it's important to know that how the buyer agent is representing its buyer. And in the event that there are disputes, going forward, if there are disputes, RealComp together with the associations are going to have to settle those disputes. So we are going to have the right to ask for buyer agency agreements and seller agency agreements, but the seller agent is not responsible for determining how a buyer is represented or whether or not the buyer is represented.
And I'm jumping to the bottom here, Brian, because it's a follow-up to what you just answered.
Mm-hmm.
So we will start using dual agency, which we know is really something they need to speak to their broker about, because each broker has their own policies regarding that. If I have a home listed and the buyer calls me, how do I handle that?
Well, I think Karen made a good point that I've been asked to be clear on. How you do your day-to-day business is between you and your broker. And people should look to their broker and to the rules and regulations that the broker has. At RealComp, we're not trying to supplant any broker methodologies for doing business. We're not interested in any of that. So you have to talk to your broker about a dual agency if you're permitted to have dual agencies. Just using, again, the legal analysis, it's very hard for me to represent, two different clients with two different goals in any kind of transaction. So lawyers are always very careful on any of those kinds of things. And you should be too, if you're going to have a dual agency agreement. But the seller agent is not responsible for the buyer or the buyer agent.
So if a buyer contacts the listing agent and the listing agent has permission to be a dual agent from their broker, they would need a buyer agent agreement with that buyer as well.
Correct. Yes.
Okay. So
or a dual agency agreement that accomplishes the goals that I set out.
Got it. And hello, Mr. Courtney. To be clear then, our buyers can use concessions from the sellers to pay their agent. We're just not allowed to use the MLS to publish those concessions. Is that correct?
So read that again, Karen.
Our buyers can use concessions from the sellers to pay their agent. We're just not allowed to use the MLS to publish those concessions.
Correct. If the seller says in their listing agreement that we're selling the house for $100,000 and we're offering $10,000 in concessions, and the buyer then closes and gets $10,000, gets the home for the equivalent of $90,000, or buys the home for $100,000 and gets a $10,000 check as a concession, and that check is used to pay a commission or some compensation to the buyer broker, that is fine. Just that cannot be transmitted through the MLS.
And I think we talked about this, but we'll mention it again because we have time. What are the consequences if you did not get a buyer's agreement signed prior to showing property?
Well, that's an excellent question. And I've talked to NAR in detail about this. The MLS is responsible for being sure that all of these rules are being adhered to. Why? We got saddled with being the watchdog for the industry. And so we're responsible for being sure that the buyer does have a buyer agent agreement in place before the first home is shown. We're going to have, if there's a disagreement over whether or not that occurred or not, because commissions are being fought over, we're going to have the right to ask for those agreements, and we're going to have fines in place that will be penalty oriented in the event that these agreements are not entered into in the appropriate fashion. Ultimately, also, the plaintiffs' lawyers and the DOJ are going to be looking at industry players to see whether or not they're trying to comply with the settlement agreement or not. And there will be the potentiality for lawsuits in the event that people are trying to get around the rules or skirting the rules. Is the DOJ going to look at every single? There's hundreds of thousands, if not millions, of residential real estate transactions every year. Is the Department of Justice going to look at each and every transaction and determine whether or not there was a buyer broker agreement in place before the first home is sold? Absolutely not. Are the plaintiffs' lawyers going to be looking at every single transaction? Absolutely not. But we as an industry are going to be responsible for policing one another and implementing this settlement. And to the extent that people are not adhering to it, there will be consequences, through the MLS and the associations.
And I believe we answered this too, but we're going to talk a little bit more about it here. When holding an open house, do I need to get buyer agency contract signed before I let consumers in?
No, because you're not representing those buyers. If somebody enters an open house and looks at the home and then approaches you and says, I didn't quite like this home, but you seem like a nice person. I want you to show me another house down the street on next Saturday. Then you're going to be entering into an agency relationship with that buyer, and you're going to have to get an agreement signed at that point. But not somebody who enters an open house unrepresented and you're not representing them, then you do not need to have a buyer agreement in place.
And this is explained in pretty good detail if you go to the facts.realtor page, and you go down to those FAQs, you'll find this information there. So if you wanted to look into it a little bit more, you'll be able to see that right there from NAR. Can commission be on the purchase agreement or only on an addendum?
Well, commissions can be on the purchase agreement. We as the MLS, again, are responsible for, we are not allowed to coordinate on the MLS or outside of the MLS any methodology for the sharing of information regarding commissions. So we as the MLS, RealComp, has a little bit of a conundrum in what kinds of documentation there is in the MLS. A purchase agreement on its face can have commissions in it. So you can say in your purchase agreement, we'll make an offer for 123 Elm Street for $90,000 plus a 2% commission. You can do that in the purchase agreement. You can do that in an addendum to the purchase agreement. Where there's going to be some limitation is where that purchase agreement can be shared in the MLS, and we're going to have limits on how that will be shared, whether or not it can be shared.
So back to the questions about dual agency, it appears that the person asking those questions is the broker. And so now she's asking how to handle the dual agency, but I'm not sure that's for us to answer. If you want to be a dual agent, there are steps you need to take to protect yourself and your clients. But I don't know that we can answer that for her.
No, all I can say is, I'll just say it from a general 30,000 foot view.
Okay.
Anytime you have a dual agency, whether it's in residential real estate, commercial real estate, lawyering, accounting, any other profession, you have it would be my advice to have it in writing, to have both sides understand fully in detail what your obligations are. And when I say both sides, all three sides, the principal side, buyer, principal side, seller, and the broker, it should all be spelled out in clear, unequivocal terms as to what everybody's obligations are and what all the compensation is.
This one is kind of interesting.
I love
I'm
interesting
not,
questions.
I don't know that I'm going to read that first part, but what liability is there if a buyer has multiple signed agreements for commission with different agents? Can other agents they have signed an agreement with go after the commission from the agent that closed the deal with that buyer?
Well, a buyer should only sign one agreement with one agent. And the agency agreement should be an exclusive agency agreement for a period of time or for a limited number of houses or one house. So that it should be an exclusive relationship. If a buyer has signed multiple agreements with multiple agents, then you're going to get into other questions of law like procuring cause and which contract came first and all of those things, which I can't really answer in sort of the abstract. So you should try to, when you sign up a buyer to a buyer agency agreement, you should try to have it be an exclusive representation for a period of time or for a period of service or for some other, clear criteria.
And I mean, if that buyer signs with multiple agents, then it sounds like there'll be somewhere somebody's going to need to talk to an attorney.
Right.
Okay. When a seller hires us, we represent the seller. A buyer calls, wants to buy the house with no agent, then they are unrepresented. I will not be an agent for the buyer. Why would you say anything about being a dual agent? Well, it's an option. You don't have to be, but it's an option.
Correct.
The buyer can still buy from the listing agent as long as they understand they're doing so without being represented.
Correct. Yep.
A dual agent only goes into place if I already had a contract with them, or if you enter into a contract with them.
Right.
A buyer
As I said, if a buyer comes into a home and that you're holding open and doesn't buy that home, but in the course of the conversation wants you to, represent them in some way or shape or form, then you have to get a buyer agreement. And if they then come back around to that house and buy the house that they originally met you in, there'd be some kind of dual agency situation going on that you've got to be clear about your rights and obligations in that situation.
Can we use sign riders to let buyers know how much the seller's willing to pay buyer agents?
Yes, in fact, you have to, or you should, if it doesn't match up with what's in your buyer agency agreement.
No, they're talking about a rider on a sign, Brian, like the for sale sign. Can they add a rider to the bottom of the sign that says, I will pay 2 chickens to buyer agents?
Can the seller have a commission on the bottom of their sign?
Yeah.
Oh, sure.
Yeah. Okay.
Pretty clever.
Let's see. You said that you can't take a greater commission amount than what is stated on the buyer agency agreement, but can revise it if the seller's offering more. Do you need to revise it if the seller's offering less than what is stated?
No.
It just can't be.
It just can't be more. So you could say to the buyer, I'm going to get when you close on your home, I'm going to get $10,000, and the seller. And I mean, I think you'd be wise to say exactly how it's going to happen. But if the seller then offers you $2,000 and you only have to take $8,000 from the buyer, that's fine.
Greetings, Miss Danielle. And I'll answer this one, Brian. Is sharing offers of compensation prohibited in showing time? Yes, it is. And I have had many conversations with showing time representatives. They are trying to come up with maybe some ways that they can help the agents. But right now, it is not advisable for you to put that information in showing time they're trying to figure out how to scrub it out or get the attachments out that have that in there. And you have to remember that Showing Time is owned by Zillow, and Zillow is a brokerage. So by Showing Time allowing you to put your compensation in there, it's like a brokerage allowing you to put it on their website, for example, which is a clear violation of the settlement. In fact, it has the strongest penalty that NAR already implemented, that said your access to the data is no more. So they have to be really careful with that. And I talked with them yesterday and today, and they're trying to work out the best ways for them to handle it. So we'll let everybody know, because this question comes up a lot. I think people are sliding it in there. And so that's why we're getting the question. What are the consequences from the MLS for not obtaining a buyer agency prior to showing houses? Who will know if I have one or not? Or if I didn't get it signed, if I got it signed after showing the house or prior to? That's a terrible question, but okay.
Well, again, everyone should adhere to the settlement agreement and its terms. RealComp's responsible for being sure that people in our MLS are adhering to the rules. In point of fact, it won't be evident as to whether or not that's happening unless there's a dispute. If there's a dispute over commissions, or if someone is consistently not getting a buyer agreement signed and it becomes known by other agents, then I'm sure there will be some bringing of this to the association or to the MLS, and we're going to have fines in place if it turns out that that didn't happen, and a dispute arises as a result of it.
If I'm a seller's agent for a relative and a buyer approaches me and wants to buy the home, obviously I would stay a seller's agent, so I would not have an agreement with the buyer. If the compensation is 6% and the seller agreed to pay 3% to the buyer agent, in this case, what would happen to the 3% for the buyer agent? Can the seller agent keep it? Well, that's up to the seller, is it not?
I think you have to, yeah, you'd have to disclose that to your seller, and if the seller said, you know what, the fact that there was a windfall to you, it's fine with me, or no, I agreed only to pay if there was a cooperating broker, and I get, the 3% is mine, if you will, then that would be the case. The agent, whether you're a lawyer or a real estate agent, the principal always has to be fully informed and agree to the arrangement. So this is principal agency law. You can't, as an agent, again, whether you're a lawyer or a real estate agent, you can't do something that the principal is not aware of to your own benefit. It's a violation of principal agency law.
And that is the end of the questions that people have submitted. I was going to look to see if there were a couple that were asked quite a bit in our other webinar, to see if we might want to, but I think it's really the same kind of questions that we're hearing here are along the same line as the ones we're hearing elsewhere. We had a lot of questions before about that pre-sale concessions, but now those are no longer being offered, so those questions no longer apply.
I'll do a couple of things, Karen. One question that came up just real quickly is, does this apply in the rental? Do these rules apply in the rental market? So no, the settlement agreement only concerns buyers and sellers of residential real estate. So to the extent that you're a commercial broker and have a commercial transaction, these rules do not apply. To the extent that you're a leasing, you're showing someone houses to be leased, and they've made it clear that they're not looking to buy, you do not have to have a buyer agency agreement. I mean, I think it's recommended that you do in all those situations, but the settlement agreement only concerned the buyers and sellers of residential real estate. Now, RealComp, but on the other hand, RealComp cannot permit the offers of compensation for leasing or commercial in its MLS. So we're not, if it's a clearly a commercial building that's at play, we're still not going to allow offers of compensation on the MLS. We cannot. But for all of you as brokers and agents, these rules do not apply in commercial situations, nor do they apply in leasing situations.
And our friend, Miss Shelley Watson, reminds us we're all in this together. We're all at risk of being sued if we don't follow the rules. And we are only as strong as our weakest link, so we should all want to comply. Our job at RoComp is to make it as clear and concise as possible, which is very difficult some days with the way things are changing. So please, if you have questions, reach out to us and we will do our very best to get you answers as quickly as possible. Don't wait. You have questions, ask us, and we'll be happy to help in any way that we can. So thank you, Michael.
Sure, you're welcome.
Um,
I would like to say to the audience out there, one, thank you for coming, but also to direct some of your questions to your associations too. We are out there and we're all trying to get on board with this and to comply the best that we can. And this is going to evolve over time for sure,
yeah,
for everybody.
absolutely.
I mean, this is the beginning, not the end of this. So,
All right,
thank
everyone.
you, Karen and Brian.
Thank you.
Thank you, everyone. Appreciate it.
Thank you. Feel free to reach out. We're here. Bye, everyone.
Bye-bye.
Thanks, everybody.